Good evening or afternoon or whenever you're watching this. Everybody is well. Please like, subscribe, share, comment. I appreciate anybody who watches this. I did a video with Farzad yesterday where I discussed this. I discussed this being Elon's case in Delaware. So I thought I'd sit down and quickly. I'm just going to do this on the spur of the moment and just kind of off the top of my head, kind of go through this. I've heard people try to explain this case. I don't think anybody has really accurately described it. We did yesterday in Farzad's case, but I don't think most people understood it, or I wasn't clear enough. But I'm going to try to be that way now. To start off, I did to let you know what I predicted. First of all, I would much prefer that parties be allowed to contract. So I am in favor of not interfering with these kind of pay packages. So I would my view is to let it stand. Two, to the extent that shareholders make a vote, I would tend to give deference to that vote, and I would really consider it beyond that. And three, that in certain situations, doesn't make a difference what you tell somebody; they're going to still support you. And you'll see that part of the argument that's made in these proceedings is that the proxy statements weren't accurate. And kind of my position is doesn't really make a difference because you could have said Elon's going to get $400 trillion, and Tesla shareholders would have said yes. So it really wouldn't make a difference even if what was said is false. But be that as it may, what went on yesterday or the day before when the court released its ruling relates back to the decision the court made. So let's go back. So let's put this all in context because people have described it like she just made a decision. She didn't just make a decision. So let me explain what went on. The 2018 pay package was raised in dispute in an action brought in Delaware. It was brought as a derivative action. So there's class action we've all heard about, and there's derivative actions. So the class action is where shareholders actually are the beneficiaries of whatever the litigation is. And in addition to the shareholders, the attorneys would get paid. A derivative action is where the action is for the benefit of the company only. And the shareholders are there by name more than anything else. So in my view, the Torrenta, the Delaware action, is a derivative action for the benefit of the company per se. And it's in essence, it's the company versus Elon's pay package. That's kind of how you have to look at least conceptually. So the company would be called a nominal defendant, and then a nominal defendant or plaintiff, and there would be actual plaintiffs like Torretta, who has I think he had 9 more shares than George Washington, the plaintiff. But be that as it may, litigation started. They contested the pay package. Eventually, it went to trial. There was a long trial, experts, etc., very involved. Now, again, my view was that they should have let the pay package stay, etc. But now we're talking about what actually happened and what the court said. And I've heard comments about procedural stuff and technicalities. Come on, guys. The law is all procedure and technicalities. That's the entire law. So I always found it odd and kind of humorous when somebody said or complained about the technicalities of the law, because that's all the law is. It's not necessarily the pursuit of justice, notwithstanding what we'd like it to be. And in this case, in this opinion, we actually have a line that kind of, I think it's a throwaway line, but it caught my attention. So we have a case, we have a lawsuit, it goes to trial. The result of the trial, which I think was in 2022 or 2023, or yeah, it would have been 2023 or 2024, when she issued her 250 or so page opinion, the judge in Delaware, was basically she found against Elon in the pay package. She rescinded the pay package. In essence, she said, pay package is out, go back to 2018. You could do what you want, but it can't be done in this way. So she found because Elon was involved and was the subject of the pay package. And since he had an ownership interest in Tesla, and since there were board members that appeared to have interests that were subject to his position, the Delaware court found that it was conflicted owner transaction. Which, and by the way, I'm not a Delaware lawyer, so don't take this as the gospel. But in Delaware, under those circumstances, what happens is instead of the normal setup where the plaintiff, the person suing, has the burden of proof, it flips to the defendant. So in this case, even though Elon was being sued under Delaware law, he had the burden of proof. And the burden of proof he had in a conflicted person case was to show that the transaction was fair across the board. That's kind of the standard. You could agree or not agree with that, but that was the issue that arose. And the judge found, rightfully or wrongfully, again, I don't think she should have been involved at all. I don't think this case should have been in front of a court, but it was. But she agreed with the plaintiff. So she found for Toretta and the plaintiffs throughout the pay package, said you could do it again, but this doesn't work. She didn't specify what would work, by the way, but that would not be unusual. After the decision, but before there's a judgment. So there's a bunch of stuff, a bunch of activities that happen in a case until you get to the final judgment. So even though you have a trial, that's not a final judgment. There's still a bunch of paperwork that goes on and proceedings. I think, as a matter of fact, as of today, is probably still not a final judgment. So after the case, and she had ruled in her 250-page ruling, under the standard, I hold that Elon has the burden of proof, and he hasn't met it to show that the transaction was fair for these reasons. The issue that was remaining was the attorney's fee issue. The attorney's fee issue was the plaintiff's counsel, so the attorneys representing Toretta and theoretically the interest of the company, they were seeking attorney's fees. Originally, they sought the equivalent of $5.6 billion in shares. So there was a bunch of briefs after the court made the decision as to the transaction was not fair. Then there were a bunch of legal briefs that were filed, and then some hearings. And the question was, what was a fair sum to be awarded? So it already presumed the outcome. Before there was a hearing on the attorney's fees, there was the decision to do a ratification of the prior vote. So that occurred. After the vote was in favor, Tesla filed a motion, in essence, to get the judgment changed. I don't think it was framed as such, but in essence, that was what happened. So the court made a decision on we would call it on the merits. After the fact, Tesla, after the second ratification, they went back to the court and said, you should change the first vote. So there was a bunch of hearings about that. That's what this ruling is. So the ruling that came out 2 days ago was on the motion to revise the trial decision and on the attorney's fees. Two separate rulings. On the motion to revise the judgment, and I had mentioned this, I spoke to Farzad about this, and I think others. Technically, and just as my opinion, I understand when they tried it, but procedurally it's improper. And I think the court even mentioned this. This would be like every trial after the court made a decision on the facts to go in and try to undo that. It wouldn't be fair. So kind of the rule is, once there's been findings of fact by the court, you can't go in and now try to change the facts after the fact. And by the way, I agree with the court as to that. And I said it to Farzad at the time. I don't think you can go in after the fact and try. And again, that doesn't relate to whether they're going to win or not later on, but this is the kind of procedure, and these are judges. That's all they do. So to expect them not to operate by procedure is not really. It's not how they operate. Maybe they should operate in a different way, but it's not how they operate. And obviously, it appears that she may have some bias or some concern about Elon. How do we know that? In that first decision, that 250-page decision, like page 1 says, basically, should the richest man in the world get more money? Basically, I'm paraphrasing. That was the very first entry, completely inappropriate statement about his wealth. Why would he be different than any other party? Why should he be treated that way? And it had a bad ring to it. It did not sound like somebody who lacked who was completely unbiased. So what was interesting to me was there's another line in this ruling. So that first one was like 250 pages. The ruling as to the two motions to revise the trial judgment that was already made and for the attorney's fees. This one is only 103 pages, but it also has a reference. So in her ruling, she goes through a bunch of analysis, but ultimately what it says is, under these circumstances in Delaware, and again, I'm not a Delawarean lawyer, but under these circumstances, even if you do the ratification, when there's a controlled shareholder circumstance, in other words, where the shareholder is the owner and it benefits him, the best it would do is it would shift the burden of proof back. So I think I told you when we started, this is unusual because even though Elon was a defendant, he had the burden of proof under some Delaware provision. So she indicated that under the ratification, if it stood up, it would shift the burden of proof back to the other side, which would be a significant thing, which might permit Elon to win. But she also described and said that in this particular case, and again, just to be clear, a judge can find any reason to find any ruling. If they're crafty and sharp enough, they could use any fact and draw any conclusion, even if they're being legit. I'm saying maybe 99% of all judges are legit, but some aren't, and those can use language and facts however they want to drive home a particular point. And I drew the first point about his wealth to suggest there may have been some bias. So anyway, and in law, unlike medicine, for example, it's not like you break your arm and everybody could see it. A lot of this stuff is subjective. It's not black and white. And so the judges have a lot of power and authority. And again, remember, this is a state judge, so it's different than a federal judge, and it's in a different system. So after going through all that nonsense, she determined that because there were misstatements in the second proxy statement, and she gave some examples, and are they true or not? I don't think they're material, but she gave examples. Here are statements that are either non-disclosures or inaccurate in the second proxy statement, which is the most recent one. And therefore, if the proxy statement is not accurate, then the ratification doesn't stand, and therefore she did not shift the burden of proof back. So that's what she did. The second part of it is, and then we'll get to the appeal after this. The second part of it is about the attorney's fees. So there was a $5.6 billion request. There was a bunch of discussion. I think the highest award in Delaware was something on the order of approximately $350 million. That number might ring a bell. But there's a bunch of theories about how you should offer it. And the problem here is because it was really hard to figure out what the benefit was, the financial benefit to Tesla was, because in essence, it's going to cost them money because they're going to have to pay out shares at a much higher rate. So it's actually a negative financial transaction to Tesla. So it doesn't work for the financial benefit. So maybe for a moment, for a split second, there's a financial benefit, but the next moment it's gone. So it's hard to see that. There is something they call a governance benefit. So if you don't operate your company exactly to the T in governance, then maybe there's a lesson to be learned and maybe there's some value. But otherwise, the plaintiffs' counsel, their attorneys, in trying to get the $5.6 billion in legal fees, they're trying to show that they provided some economic value. And the judge in this part of the decision was trying to figure out how to figure it out. And she indicated that she was having a difficult time too. So it ended up being she couldn't really take the plaintiff's position, because underlying all this in attorney's fees in Delaware, and again, I'm referencing Delaware, and I'm not a Delawarean lawyer, attorney's fees can't be a windfall. So if, for example, the greatest award in the history of Delaware was $300 million, you couldn't have a case where somebody's going to get $3 billion, three with a B. That would be a windfall. So that's kind of an overlying principle. It can't be so over the top. $5.6 billion sounds like it's over the top. 345 million is over the top too, but they haven't collected anything as of now. And they can't at this point in time. But what she did is she said from plaintiffs, she really couldn't get or at least she indicated she couldn't get a specific formula that worked. There was another formula that was thrown out. It's called quantum merit, which is the reasonable value of the services, which basically takes a look at the number of hours and multiplies the rate, maybe adds a factor based upon complexity or how deep into the case you had to go, and that gives you a number. And by the way, that's what I had suggested, and that's also what Tesla suggested, and that would give you a number like, I think it's a big number, but it'll be like $50 million, something like that. What the judge said instead is they used the value of the options, which was, I think, $2.6 billion, and then she calculated a percentage of that as the fee. She referenced 11%, but said, I didn't understand why, but instead she got 15. So 11% would be about $80 million less. So it'd be in the high twos, but that's 345. So it's 15% of the $2.6 billion savings in that option grant. That's how she calculated. But it seemed like a very uncertain number. It's a very large number. I thought at what I had predicted, I thought the outcome would come as it did based upon her comments. But I thought it would be safer for her, and it would be easier for her to withstand an appeal if it was no more than $100 million. So she exceeded what I thought was a safe range. But anyway, it's a bunch of mumbo jumbo, really. It was very vague, not clear. But the one line in here, it's page 77 of the order, and it caught my attention because I remember the line in the first document where she referenced his wealth. And, we all like to hope that the courts look for the truth and justice. And here's the line with that in mind. And the line is, in search, and this is where she's talking about trying to figure out the attorney's fees. In search of a defensible valuation approach that avoids the windfall problems, the analysis turns to defendants' arguments. So when I saw that, it wasn't that she was looking for the truth. She was looking for a defensible valuation, defensible from an appeal. So to me, when I put that together with the first statement about or what appears to be bias, along with this little throwaway statement, the defensible part made me really uncomfortable, and I think is evidence of bias. So she found that formula, and what's going to happen from here. So there could be some agreement between the parties where they resolve everything and the case is dismissed, but the a judge would have to sign off on that most likely. And if it's this judge, probably not, but could it be a different judge? Perhaps it might be a different judge. And perhaps I kind of predicted that the current judge may not be on the bench for the duration, that she may take a job at a law firm, a high-paying law firm. That's what I've been kind of anticipating. So you could have some agreement, or maybe some new judges involved. There's a sign-off, and maybe there's a deal, a monetary deal, but the pay package stays. That might be a hard sell, but I'm sure that'll be something that's explored. There obviously can be an appeal to the Delaware Supreme Court. Delaware, that appeal is due 30 days after the judgment is entered on the records of the Delaware court, which it has not as of now. 30 days to file a petition. They say on average in Delaware, in a average case, 300 days about from start to finish, once from filing to the end. This case, I would say, is not average, so I would add another. It could be fast. I mean, you could ask for an expedited proceeding, but it's probably very complicated, so I don't think it's going to be expedited. And I would add on 300 days plus another 6 months, just kind of a guess as a rough range. And in that case, they could argue about the trial. They can't argue about the facts because the facts are the facts. So the appellate court, in this case, would be the Delaware Supreme Court. It would look at the case, accept the facts as true, and would look at the law that was applied. In this case, the question to me is this kind of action for the benefit of the shareholders? Is the statute properly clear? Is the attorney's fee award an unlawful penalty? And there's a bunch of other arguments, constitutional arguments, I think that'll be made also. Because is it an improper taking? Is there a issue of due process issue? Is there a violation of the Commerce Clause? There's a whole bunch of arguments that'll be raised in the Delaware Supreme Court. What can the Delaware Supreme Court do? After they look at all this stuff, they get a bunch of briefs. There'll be oral argument where there's an argument, and then they'll decide it, and they'll draft some kind of order related to the hearing. Their order can be they could accept whatever the existing order is and not do anything. They could take part of the order and change it, so they could accept that perhaps there's a governance issue, but say the attorney's fees are improper, send it back to the trial court, or they could put their own number in, or they could reverse entirely. They could reverse the entire case. They could enter their own order, or they could send it back to the court, the trial court, for further proceedings. Now, again, they may send it back to the court, but is the same judge there? Not necessarily. But those are all kind of things that can happen in the Delaware Supreme Court in that time frame. 30 days after the order is final, 300 days plus 6 months is my kind of ballpark to get in a ruling in the Delaware Supreme Court. And then depends on what the ruling in. If it's a final ruling, then it's final. If not, and it goes back to the trial court for further proceedings, then it would continue. But once it's final, then if they wanted to file an appeal in the Supreme Court, they could. It's not required. Whereas in the Delaware Supreme Court, there's I think an absolute right to an appeal. In the U.S. Supreme Court, there's not. And it depends on the issues that are raised. The question is, does the obviously the court, I think, would be somewhat inclined to be sympathetic to Elon. The problem is this is a state court's judgment. So kind of the position is to give states more rights. So infringing upon the state's interpretation of their own law, in this case, it would be the trial court in Delaware and the Delaware Supreme Court, kind of goes against the theory of the current Supreme Court. So they could obviously rule in favor, but I'm saying that's a stumbling block to go. I think there's a bunch of constitutional arguments that may be persuasive to the U.S. Supreme Court, and at some point in time, I think it's very likely, at some level, that he's able to unwind a significant portion of this particular ruling. But when that is, we have to kind of think about the timeline. So if we went out a year and a half, that would bring us into 2026. This is just so we have a fair timeline. That would be 2026, which would mean really, if it could go directly to the Supreme Court, that would mean you probably couldn't get a ruling from the Supreme Court until spring of 2027. So have that as a timeline. In the interim, obviously, they could pass a new pay package in Delaware. They also could pass a new pay package in Texas. It might be subject to litigation. It could be subject to litigation, subject by plaintiff in the action, saying they're trying to circumvent the judgment, etc. But I think in Texas, it's likely that Elon will prevail, but it can be challenged, and I'm sure it's going to be challenged because there's a lot of money involved. So, so I think at some point in time there may be a legal resolution in their favor at some point in time, and there could be a negotiated resolution and perhaps a dismissal based upon who's the judge and what they're allowed to do and who else could perhaps intervene. Other than that, I don't see a resolution. I don't think Tesla or Elon is going to lay down. And plaintiffs' counsel, and again, I think this whole case is a case designed on attorney's fees. Plaintiffs' counsel, who originally wanted $5.6 billion, are not going to run away from the 345, I think it's $345 million. That's a lot of money even for a lawyer. So anyway, I expect a bunch of litigation, but again, if there could be some resolution on a financial basis where the pay package stands, then that's great. But otherwise, all that can be done. The pay package, I think, and withstand scrutiny. The only question will be the cost to Tesla will be higher, and indirectly to shareholders, because the cost of the shares to give the same value to Elon would be higher at this point in time. And that's kind of the issue, and it was expressed by experts in some of the opinions. So that's where we are now. We're still waiting for the final entry of judgment. It'll be at that point in time when the appeal process in Delaware starts. I'm sure there'll be communications amongst the parties, and I will follow it. It'd be interesting to see what the arguments are in the appellate court. I really happen to think the statutes are pretty vague in terms of what's a benefit to this to the company, because in this case, I think it's a detriment to the company. I think it's clearly it's a financial detriment, and it's a key man risk, obviously, and it takes away time, effort. There's so many negatives, so I don't see it as a benefit to the company. I see it as solely as a benefit to plaintiff's lawyers in this particular case, and to the plaintiff himself, again, who has 9 more shares than George Washington. Anyway, I hope this wasn't too long. Hope it made sense. If you have questions or comments, you want to put them there, feel free. I will take a look at them, and I'll kind of follow these proceedings from this point in time. And if I see anything where I can try to be helpful, I will. I know sometimes this stuff is very confusing. It's confusing to me too. And this is a very novel matter, so don't feel bad if you're confused, because nobody has, or there's very little experience about this. And that's also why it's more subject to appeal. There's not like a ton of cases in these very unusual circumstances. And because of that, there's more variance probably in the appeals. So you really don't know how they're going to turn out. Maybe a greater likelihood of them being successful. There's usually a very small likelihood, under 20%, 25%, under, depending on the case, depending on the judge. And again, civil cases versus criminal cases. But there's usually a lesser percentage of being able to prevail on an appeal. Obvious reason is because the appellate courts don't want cases either. So if they started granting all kinds of appeals, everybody would be filing an appeal, and they wouldn't like that. So they're not like big fans of granting, but they do on in the appropriate circumstances. But to have an expectation about it, I don't think I would. I would feel better in this before the Supreme Court, and to the extent there's some constitutional issue involving violation of due process, the Commerce Clause, something else that somebody who's a lot smarter than me could assert. And I'm sure there will be some very fine constitutional lawyers that will be on there. Anyway, sorry to ramble on. Be well, take care, have a great night, and see you soon.